हाँ ये आ रही है बोला इसको बबलू को
Ms. Arora is leading us for the petitioners, Mullahs, in the first matter.
हाँ
The senior counsel.
Please, my lords.
Mullahs, we are opposing any kind of.
Post lunch, Mr. Ravin Srivastava.
No, I'm sorry, Mullahs, we are opposing it. Mullahs.
अच्छा
My lords, and the matters don't get taken up. That's the whole problem, and it's being delayed for a long time. It's totally covered by a judgment.
Let him come. This is the matter. चलिए कोई दिक्कत नहीं हटाएंगे. चलिए start करिए.
My lords, very well.
Serial number 4,
Good,
I
my
would,
lords.
would like to withdraw,
Good,
my
my-
lord.
Serial number.
Connected. Serial number 4, my lord.
Serial number-
WPS 906/2024.
Serial number 4.
My lords.
मोहित कुमार इसमें क्या चैलेंज किया था आपने
My lord, the same notification challenge the petitioner does not want to press. She is
अच्छा
present before the court.
अच्छा क्या नाम कोई विड्रॉल की एप्लीकेशन है क्या
My lord, we have filed today, my lord.
वो मंगा दीजिए द लर्नेड आ गई है द लर्नेड आपका नाम मोहित कुमार है
My lord.
The learned counsel for the petitioner states that the present withdrawal application has been filed by the petitioner for withdrawing the present petition. Accordingly, allow करके dismiss as withdrawn.
Oblige, my lord.
चलिए हटाइए चार नंबर dismiss allow कर दीजिए applicant withdrawal dismiss कहाँ application इनकी हाँ allow कर दीजिए withdrawal की application withdrawal application dismiss as withdrawn. चलिए हटाइए अब बची तीन बची
Please, my lords. May I request my lords to take up Bhuvneshwar Sahu matter, please?
अच्छा एक नंबर में हाँ भुवनेश्वर साहू
Please, my lords. My lords,
you are for the petitioner.
Petitioner, please, my lords, please. My lords may just see what is the challenge in this petition. If my lords may see, we have challenged a notification dated 4th of May 2023, by which, my lords, there is.
आप लोग you are the petitioners हैं
We are the
DED
DED
क्या?
candidate.
Diploma,
Yes, we are
B.Ed.
आप लोग
we are-
DED
we
ये
are
लोग
not.
DED हैं तो ये जो modification हुआ इस notification से they are agreed by that कि जिसमें DED के साथ B.Ed को भी इन्होंने कर लिया ना This is what-
Absolutely. That is the short issue.
अब इसमें देखिए,
That's a very short issue.
एक चीज ये बताइए कि मैडम आप बताइए यू आर ऑल्सो इन द सेम फुटिंग मिस्टर राजीव श्रीवास्तव आप लोग सब B.Ed वाले हैं ना
सब एक सेम फुटिंग
हाँ तो अब सुप्रीम कोर्ट का जो जजमेंट है और जो नोटिफिकेशन है जो एनसीटी की जो 18 का वो है वो कॉश हो गया और सुप्रीम कोर्ट ने जो है अपहेल्ड कर दिया रिगार्डिंग दैट राजस्थान हाई कोर्ट का जजमेंट विद द रीजन है ना उन्होंने ये होल्ड किया कि जो DED है एलिमेंट्री प्राइमरी एजुकेशन है 1 to 6 है कि 1 to 5 है
1 to 5.
and thereafter B.Ed onwards
Yes,
6 onwards
yes.
so how do you distinguish your case from the judgment of the apex court which is squarely covered
My lords,
not only the P, the original writ petition was
Yes.
also before the Supreme Court.
yes वो देख लिया था उन्होंने उसको कॉश कर दिया था और उनका ये कहना था एनसीटी अथॉरिटी है तो इट कैन नॉट मैकेनिकली
My lord,
आप कह रहे हैं कि उसको B.Ed he has to give the reason
when review has been filed.
my lords, also one thing, if I may,
Wrong
This
statement.
aspect is
May
This
I-
aspect is wrong, your lordship.
My
Review
lords,
is still pending before the
can
order of
I-
the Supreme Court.
No, no,
my
no.
lords,
रिव्यू
let me-
रिव्यू
Review
नहीं,
is
ठीक है,
wrong
ठीक है,
statement.
my
ठीक है,
lords,
ठीक है।
I want to say
Madam,
something here.
Madam Arora, you just hold on. Your
Yeah,
submission
because-
is that your case is squarely covered by the judgment of the apex court.
I have also one more submission in
Yes, what is
addition
the
to that.
other submission?
That is that I have filed a compilation. Subsequently, large number of people, like the present respondents, came up before the Supreme Court asking that the judgment should be made prospective and it should not be retrospective. Supreme Court has dismissed all those applications. I have filed a full compilation of that. So today, this issue is no longer res integra. Certain applications were filed for modification, they were dismissed. I have filed a whole list of them before. Therefore, this submission that
when
is-
you have filed, madam, when you have filed that application.
my lords, my learned colleague will just circulate this.
Yes, Mr. Ishan Verma, Mullahs, this is a compilation of order.
Where is Ishan Verma? Ishan Verma कहाँ चले?
Please, just coming, lordship.
हाँ बताइए कौन सा ये आप
This is a compilation. It's a small compilation of about 60
आप लोग
odd
बताइए
pages.
आप लोग ने एप्लीकेशन फाइल किया सुप्रीम कोर्ट में कि फॉर that the judgment would be
We have not filed.
कुछ लोगों ने जो मैडम ये आप लोग कौन-कौन है इसमें?
We have already earlier supplied the copy.
अच्छा
We've
सप्लाई
not
कर
received
नहीं,
any
we have not
copy.
received
We've
the
not
copy.
received any copy, Your Lordship. The
They have-
compilation.
अच्छा वो छोड़ दीजिए
Modification.
okay it is prospective or retrospective there is an order of the Supreme Court whether it concerns you or not it is
उसी पे, that is the only issue, Your Lordship.
That is the only issue.
हाँ तो उस पे आपको एड्रेस करना है कोर्ट को
जी।
रेट्रोस्पेक्टिव जब सुप्रीम कोर्ट ने ऑलरेडी उस चीज को होल्ड कर दिया है कि सब डिसमिस कर दिया तो व्हाट यू वांट टू एड्रेस टू दिस कोर्ट गो एंड एड्रेस टू द सुप्रीम
No,
कोर्ट
no, Lordship. Lordship, the same judgment of the Honorable Supreme Court, Devesh Sharma, is actually protecting
भाई
the
रिव्यू
people.
फाइल कर रखा है रिव्यू जाके कंटेस्ट कर लीजिए
Lordship, I kindly appreciate ये जो स्टेटमेंट्स दे रहे हैं कि बहुत सारे पिटिशंस खारिज हो चुके हैं. I also have a status report, Your Lordship. If the honorable court want to just have a look at it, there are many petitions which are pending. Petitions from Madhya Pradesh High Court, petitions from
ठीक है
Bengal,
मैडम
everything
देखिए
is pending
अगर
there
सुप्रीम
before the honorable
ऑनरेबल
Supreme Court, Your
एपेक्स
Lordship.
कोर्ट ने किसी की भी एप्लीकेशन जो आइडेंटिकल थी अगर खारिज कर दिया तो इट विल बी एप्लीकेबल टू योर एप्लीकेशन आल्सो
My lord may kindly appreciate.
हाँ बताइए
It was that before the Rajasthan, it was said that the state of Rajasthan was justified in calling the B.Ed candidates because till the notification was valid, the state of Rajasthan, while conducting issuing the advertisement and conducting the recruitment, could not have excluded the B.Ed candidates, my lord. So a rule is, my lord, valid till it is not declared, my lord, ultra virus. And my lord may kindly see the candidate, the D.Ed candidates, in one petition, my lord,
Mr. Srivastava, the thing is that
my lord, our rule is still valid.
नहीं वो
Rule is still valid. Rule has not
वैलिड
been
है
fought.
या नहीं है मतलब ये तो ठीक है बट द इशू विच इज इन्वॉल्व वेदर द DED BA can be also part of this recruitment process यही है ना
यही
कि वो जो इंक्लूडेड है by this notification अमेंडमेंट जो किया है वो सुप्रीम कोर्ट ने हेल्ड कर दिया कि नहीं वो नहीं हो सकता
My lord, Supreme Court has said, what said, my lord, that the notification, my lord, the date on which the rule was.
मिस्टर श्रीवास्तव प्लीज होल्ड ऑन देखिए जब एपेक्स कोर्ट का एक ऑर्डर आ गया आप कहते हैं रिव्यू फाइल कर रखा है जाइए वहीं से करा लीजिए हम कैसे उसको इंटरप्रेट कर सकते
हमने
हैं
फाइल नहीं किया है रिव्यू.
आपने नहीं किया किसी और ने किया है ना चीज तो वही होगी ना मैडम एक आदमी सेपरेट तो नहीं फाइल करेगा ना तो आप वहां जाके फाइल कर लीजिए आप अपना डिसाइड कर लीजिए दैट इज ऑल खत्म बात
My lord, may,
बट एज ऑन डेट दिस नोटिफिकेशन कैन नॉट बी होल्ड गुड
my lord, may kindly see, my lord, in our petition, my lord, the rules are not challenged. What the challenge was the notification.
No, no, rule is
Yet
not changed.
can-
In
नहीं,
that case,
हमारी petition में नहीं.
Because in fact, two high courts have already applied Devesh Sharma's judgment. Because two high courts have identified.
What
We have put that in the compilation. Two honorable high courts have applied
My
the
lords,
principle.
Patna High Court and Uttarakhand High Court matters like identical to this came up before Patna High Court and Uttarakhand High Court. We have enclosed those two judgments also. They, following Devesh Sharma, have allowed those petitions and have held that only the DED candidates are eligible for the purposes of considering their recruitment till the primary this thing.
ठीक है
And my lords, the B.Ed were not allowed. Those judgments are also enclosed in that compilation.
चलिए हम लोग देख लेंगे
My lord, my lord, in my petition,
petition में हम लोग उसको तो कोई challenge ही नहीं है.
हैं?
Also, my lords, there is a,
and
can
second
I-
thing, my lord, the
ठीक है yes.
DED candidates, my lord, they
एक-
part.
एक
they
सेकंड
part-
जैसा प्रेयर आप लोग की देख लें एक तो इसमें तो वही
yes, my lords. My lords
Prayer
may
just-
turn to the prayer, which is my lords will find
एक
at
सेकंड,
page
एक-
number
एक 4-5 पेज
34.
का यही है एडवर्टाइजमेंट जो इफेक्ट
Yes.
My lord,
Yes, my lord.
madam,
My lords, can I just pause for a moment if my learned colleagues on the other side will allow me? I have made a very relevant statement. Hanji.
let madam complete her.
Yes, yes. So, my lords, I want to point
First of
out
all,
that
madam,
this
just,
is a,
we want to have the look of the prayer what you people
yes,
have
my
made.
lords, immediately, page number 34 bottom,
34 top.
34 bottom at 35 it starts, my lords. 10.1 is the prayer. Strike down the impugned notification of 4/5/2023 issued and as illegal ultra-virus. Then my lords may please come to 10.3 there. That this court may kindly be pleased to set aside, quash the advertisement of 4/5/2023 to the extent it allows the candidates possessing qualification of B.Ed holders have been declared eligible for the post of primary teachers to participate in pursuant to impugned notification dated so and so. Now, my lords, the second one is also to strike down the Annexure 1, which is the rules, which is impugned Annexure 1, Schedule 3 of Chhattisgarh School Education Services Recruitment and Promotion Rules for being arbitrary, illegal, and ultra-virus. Now, my lord, may please see strike down the notification, which is NCTE notification by which B.Ed was made as, yes. Now, my lords, the important thing that I want to bring to your notice in my present petition is page number 19, my lords.
19.
If my lords, yes, please
21.
take page number 19. Yes. Now, this is a notification or an advertisement which is dated 4th of May 2023. Please see page number 19, paragraph 8.27. Actually, paragraph 8.26. At the time when the government of Chhattisgarh came out with this, Rajasthan High Court had already struck down the NCTE, that notification of 2018, by which B.Ed had been made as an eligible qualification for teaching at a primary school. And the matter was pending before the Supreme Court. Now, my lord, said NCTE notification by which B.Ed became eligible was an all India notification. It was a central government act, so therefore it was issued under the central legislation. Once that qualification had already been struck down by Rajasthan High Court, it applied across the country. The qualification of B.Ed was gone. Supreme Court had not stayed the judgment of the Rajasthan High Court at all. It only had passed an order subject to the outcome, which the Supreme Court eventually in August of 2023 upheld the Rajasthan High Court judgment. Therefore, even on the day when the government had issued this present impugned notification of 4th May 2023, the B.Ed qualification was not eligible to apply for the position in primary teachers. Therefore, I wanted to bring to my lords a notice 8.26 and 8.27 of my petition. My lords have 8.26 at page number 18. That against order dated 25/11/2021. This was a Rajasthan High Court judgment by Honorable Rajasthan High Court in writ petition so-and-so and connected SLP number so-and-so is pending adjudication before the Honorable Apex Court, and the Apex Court, while order dated 15th March 2022, has been pleased to put on hold decision of Rajasthan High Court with the stipulation. My lords, there was no stay. It was only said subject to the outcome, further orders passed by the court. Now, my lords may see 8.27. Petitioner seeks attention of this honorable court to relief granted by Rajasthan High Court in the same subject matter with the stipulation appointments of primary school teachers in Chhattisgarh shall be subject to the final outcome. That was what we had prayed before this honorable court. So, my lords, on that date, clearly, the B.Ed candidates were not eligible at all for purpose of appointment. Now, in this context, if my lords may please come to the judgment of the Rajasthan High Court, which was standing on that particular day, which is annexed to this particular petition. If my lords may, the judgment starts at page 101, but my lords can immediately come to page number 134. Yes. And then, my lords, I will take my lords immediately to Divesh Sharma judgment.
Yes.
So, my lords, this was the notification that had been passed by the central government, making B.Ed as eligible, which is 28/6/2018. My lords will find this notification at page 109. Now, then they say, we summarize the conclusion as thus. The impugned notification dated 28/6/2018 is unlawful because it is under the direction of central government, which power central government under subsection 1 of section 23 of the RTE Act did not have. So, I'm sorry, my lords don't have that. My lords find it. Do my lords have page 134?
Yes, million. Yes.
My lord said summarizing the conclusions of the judgment of Rajasthan High Court. Then the next one, that it is not in exercise of a power of the central government under subsection 2 of section 23 RTE, relaxing eligibility criteria prescribed by NCTE, nor there has been any exercise for ascertaining the existence of conditions precedent to exercising of such powers. Then, my lords, the next, petitioners have locus standi to challenge the notification, merely because additional qualification is recognized as one of the eligibility criteria, petitioner cannot be prevented from challenging it. My lords, that's the same status with all the present petitioners before you. Accepting a candidate with B.Ed degree as eligible for appointment and thereafter subjecting him to complete the bridge course within 2 years of appointment is in the nature of relaxing the existing eligibility criteria, which central government could have done only within subsection 2 of section 23 and subject to existence of circumstances necessary for such a power. State government could not have ignored. My lords, this is on the fact that the state government did not allow them. So the court said, no, you should have allowed till such time as we set aside the notification, which it did. Now, paragraph number 50. In the result, impugned notification dated 28/6/18 is set aside. Then the letter dated 30th May 2018 of MRD to NCTE, being in the nature of internal communication, does not give rise to a cause of action, but they set aside this. My lords, may just take now Divesh Sharma, what Supreme Court held. My lords, I have requested my colleague there to pass on a copy of the judgment in Divesh Sharma. My lords, have the judgment in Divesh Sharma.
Yes, madam.
My lords, would my lords take paragraph 64 straight away? Paragraph 64 of Divesh Sharma.
Page 22.
At page number 22.
Para 65.
Yes, my lords.
Yes.
Under these circumstances, my lords, this was then Supreme Court while considering Rajasthan High Court judgment. Under these circumstances, we are unable to comprehend as to what was the pressing need to include B.Ed candidates who are admittedly not fully trained to take up primary classes. Consequently, decision of NCTE to include B.Ed as a qualification for teachers in primary schools seems arbitrary, unreasonable, and in fact has no nexus with the object sought to be achieved by the Act, that is Right to Education Act, which is to give to children not only free and compulsory, but also quality education. My lords, may I just pause here for a moment? It is my submission that under section 23 of the RTE, there is a prescription of a bridge course. Now that bridge course is 6 months. It is an admitted position, and I have placed a document on record through RTI that as of today, there is no institution in India which is recognized to give this bridge course to B.Ed candidates for making them eligible for taking classes for primary level. And in any case, that can only be done as a special relaxation only if the D.Ed candidates are not available in sufficient numbers. Now, that is not the case anywhere, either before my lords or for that matter before Rajasthan or anywhere. That is not the position. So this is what the Honorable Supreme Court in paragraph 64 actually intended. My lords may see 65 and then I'll take to the operative part of the judgment. I won't dilate on too much. I understand my lord's time is valuable. My lords, 65. In our considered opinion, therefore, NCTE was not justified in including B.Ed as a qualification for appointment to the post of primary school teachers, a qualification it had so far consciously kept out of the eligibility requirement. Rajasthan High Court by the impugned has rightly struck down. I just read that the same thing to my lords. Would my lords now turn to the operative portion? Would my lords please come to, my lords may come straight away to paragraph 77.
Page 25.
Page number 25, my lords.
Yes.
My lords have paragraph 77.
Yes,
May I read
yes.
from there? Yes. The decision whether to include or exclude B.Ed as a qualification for teachers in primary school is an academic decision which has to be taken after proper study by academic body NCTE, and it should be better left to this expert body. My lords, I may just point out here the minister had taken a decision and the NCTE had no role to play, and by that the central government had issued the particular directive. But as we have seen, decision to include B.Ed as a qualification is not an independent decision of NCTE, but it was a decision of the central government, and NCTE was simply directed to carry out that for being a direction under Section 29 of NCTE Act, a direction NCTE followed. In the present case, and in the larger context of the matter, we cannot even see this policy as policy decision. But without getting into this argument, and even presuming for the sake of argument that the decision taken by the government level to include B.Ed as a qualification for teachers as primary level is a policy decision, we must say that this decision is not correct and it is contrary to the purpose of the Act. In fact, it goes against the letter and spirit of fundamental rights enshrined in the Constitution under Article 21A, as against specific mandate of the Act, which calls for a free, compulsory and meaningful primary education to the children. By including B.Ed as a qualification for teacher for primary school, central government has acted against the provision of Constitution and laws. The only logic given by central government to include B.Ed as a qualification is that it is a higher qualification. This we have already seen is not correct. Under these circumstances, my lords, the court goes into detailed reasons that this is not correct because B.Ed is not qualified to teach a primary school. That is before this. Under these circumstances, we have no hesitation to say that the notification has rightly been quashed and decision of the division bench of the Rajasthan High Court has to be upheld. In our considered opinion, therefore, direction of the central government dated 30th/5/2018, culminating in notification dated 28/6/18 of NCT, are violative of principles laid down in the RTE Act. And not only this, the notification goes against the purpose and mandate of law, which is to provide meaningful quality primary education to children. Entire exercise is also procedurally flawed. The notification dated 28/6/18 is not an independent decision of NCTE taken after due deliberation, but simply follows direction of central government, a direction which fails to take into consideration the objective realities of the day. Then, my lords, then the paragraph 82, having made the above determination, we all the same are of the considered opinion that Rajasthan was in error for not calling for B.Ed. That is, my lords, they say that at the first instant, at that time, the notification was not struck down. So therefore, the state government could not have gone against the government notification, but only once it was struck down, then they could not have been considered. Now, my lords, please consider in the present case that when the Chhattisgarh government called for the in the advertisement for recruitment to the post of primary teachers, Rajasthan High Court had already struck down the NCPE, which was a central notification. So the notification didn't hold the field as a qualification of B.Ed candidates for teaching in primary level. My lords, the present case is actually much worse than what was before the Rajasthan High Court, for the reason there was a notification, central notification already struck down. Now, my lords, this being the judgment of the Honorable Supreme Court, let me take my lords through that brief compilation and only few relevant orders, and my lords, the judgment of the Patna High Court very, very briefly, and the Uttarakhand High Court. Uttarakhand High Court is only one page. Before Patna High Court, various grounds were urged. So the court has gone into including on the aspect of whether retrospectivity or prospectivity. They said the judgment of the Supreme Court is very clear. If it has to be prospective, it has to be specifically stated. The judgment of Supreme Court does not say so, and therefore the judgment is treated as being binding. And if any action, they are not eligible, even if there were advertisements that have been issued, those advertisements will be bad to the extent they make B.Ed as a qualification. My lords have the compilation, my lords?
Yes, but yes.
Yeah.
Please.
If my lords, yes. So if my lords may take the very first one, which is the order of the Supreme Court in Bhagwan Krishna matter. My lords, what we have tried to do is to extract the prayers and then place the order of the court before my lord, so that there is some connection, because these are orders disposing of applications, so that my lords have some connect with what was the relief that was asked before the Supreme Court. The very first matter was actually a writ petition before the Honorable Supreme Court, decided after Divesh Sharma, Please see page number 2 and the prayer of the Supreme be made before the Honorable Court. My lords, have page 2. Yes. So, my lords, in this case, which had come, again, there was a relief for quashing of that notification of 28/6 and notification of 10/4/23, which was issued by the governor of Bihar, my lords, and an advertisement. My lords, please see, our advertisement is also of 4th May, and here the advertisement was of 30th May 2023, issued by Bihar Public Service Commission, and my lords, the notification, the same notification of the central government of 28/6. So all these were asked for, they sought to be quashed. And then, my lords, the next is appropriate writ in the nature of mandamus to direct respondents not to treat B.Ed candidates as eligible for the post of primary level teachers in the school. And then, my lords, against the next prayer is mandamus to direct respondents to treat only D.Ed candidates as eligible. Would my lords please come to page number 4, the order passed by the Honorable Supreme Court. And my lords may also note that state of Bihar at this stage was not a party, but just look at the order that was passed. Present petition has been instituted seeking invalidation of notification. We can leave that. And my lords may just come down to the next paragraph. In the judgment of this court, delivered in civil appeal so and so from SLP titled Divesh Sharma on 11th of August 2023, the said notification has been directed to be quashed.
We are not getting. Where are you reading?
My lords, page number 4, the compilation. I'm so sorry.
Compilation से यही जो आपने दिया है ना, इसमें पेज नंबर 4 तो
ऑर्डर है my lord, सुप्रीम कोर्ट का भगवान कृष्णा में सुप्रीम कोर्ट का ऑर्डर है.
मैडम, यू आर नॉट गेटिंग. ये तो कुछ और है. राजेंद्र सिंह वाले केस, ये तो राजेंद्र सिंह का केस है. कोई पेज page?
नहीं. I think my lords have the old compilation. Just give me a moment. I have it. I will take it out in this also, perhaps.
Page 58.
Page 58.
Now we are not.
Bhagwan Krishna.
Yes. My lords, I may have a little difficulty because pages I have marked in the other one. So just please accommodate me in that.
ये तो स्टेट ऑफ बिहार का है. 58 पे वही पढ़ रहे हैं.
Bhagwan. Yes.
Yes, my lords may turn to page number 55 in this.
हाँ, page number 55. C4 जो लिखा है ना.
Yes, my lords, P4 which is written.
जी.
Yes. So, my lords, in this, please see the second paragraph on that page. I have just read the prayer that in Bihar, the advertisement had come on 30th of May 2023 by the Bihar Public Service Commission, and that was challenged in a writ petition before the court. My lords, this is the order. In the judgment of this court delivered in civil appeal so-and-so, Divesh Sharma, said notification has been directed to be quashed. By this judgment, this court upheld the decision of the Rajasthan High Court quashing the notification. We apply the ratio of the said judgment in this writ petition. The present petition stands allowed in terms of prayer A. I hope my lords have that prayer.
Yes.
I had just read that prayer. There was that advertisement. To the extent the same relates to notification issued by NCTE on 28/6. Consequential advertisements, my lords may mark these words, and other subsequent steps taken pursuant thereof shall stand invalidated. So once 28/6/2018 notification went, all advertisements and steps taken consequential thereto shall stand invalidated. The state of Bihar is not a party before this court in this petition. As such, we make no comment as regard notification issued by state of Bihar, the legality of which has been challenged in this writ petition. But this court expects state of Bihar shall take into account judgment of this court delivered on 11/8/2023. So my lords may mark that. Now, my lords, the next one was, there was an application moved before the Supreme Court that in case of Bihar only, that all the exams had been held apropos to the advertisement, but before the judgment of the Supreme Court. They wanted that the result of B.Ed candidates should be declared. This was in the case of State of Bihar versus TET teachers. My lords, there also Supreme Court dismissed that particular application, and my lords will find this particular order at page number 58. It starts, and the order is at page number 59.
We can directly come to 60.
Yes, my lords.
58.
It is at 59.
Yes.
Yes. My lords, here it was those people who had filed that application that their result should be declared. And this was State of Bihar which had filed this application that the result should be declared. Please see page number 659. Learned Senior Counsel for the petitioner seeks leave to withdraw. Permission is granted. Special leave petition is disposed of at withdrawn. So Bihar, realizing the judgment in Bihar, Krishna, withdrew its application also, or its petition, so far as this is concerned. Now, my lords, there was yet another matter that came up before the Supreme Court. This was Dipankar Gaurav. And here there was a petition that had been filed by the B.Ed candidates. I will just read, my lords. Unfortunately, in this compilation, the prayer is not there. Allow me to read what was the prayer.
Madam, I think the compilation is reached court, so should we go on to the earlier one because that will have the prayers also. I'm sorry. Can the
Just
69 pages compilation be tendered, please? Mr. Vikas Kaushik, can you please do it? I'm sorry for the inconvenience. Yes, it is just reached. It is just being tendered, the 69 pages, 2 copies.
My lords, I'm so sorry. We should have... My lords, if you don't see the prayer, then the whole thing becomes irrelevant. No, how would we understand what was the order that was passed? My lords will find in this particular case of Dipankar Gaurav, the prayers...
ये तो भुवनेश्वर साहू का इन्होंने दिया.
Yes, yes.
My lords, this is a convenience compilation of the orders passed by Supreme Court from time to time. It also has the prayers in Bhagwan Krishna.
Which page you are reading?
My lords, page 12 at 13.
12 and 13. Achha.
Yeah. This is another writ petition that came to be filed before the Supreme Court. And here, this is the B.Ed candidates who had filed, and they wanted that their results of examination should be declared. My lords may just see page number 32.
The date is
Writ
also...
of yes, and this is filed, my lords, on 20. Please come to page number 14 at page number 15. Dismissed as withdrawal. Yes. Now, after this, my lords, there was yet another matter which was filed, which was an application which was filed, which was in the case of Arnab. My lords, please come to page number 16 at 17. This was an application for modification and clarification, again
Devesh
filed
Sharma.
by the, in Devesh Sharma, but by an applicant called Arnab Ghosh. Page, my lords will find it at page 16.
मिल गया. Yes.
Now, if you may come to page number 17, this was his prayer. He said, modify or clarify that any recruitment process that had commenced prior to judgment dated 11th August 2023 by Honorable Supreme Court, this was, shall not be interrupted, and appointments shall continue to be made as per recruitment notification to the post of primary teacher issued prior to 11. So directly a prayer say that whatever has been done has been done. If you have started, please allow it. My lords, at the first instance, the registrar of the Supreme Court rejected this application as not being maintainable, and he said that this application cannot be filed. It is more in the nature of a review. My lords will find his order from page number 18 to 26. So please come to page number 26. Actually, page number 25 bottom. The registrar rejected it. Supreme Court also rejected it. My lords, page 25 bottom. Aforesaid principles laid 7, my lords. The same party filed an IA in the civil appeal itself. And my lords, see the prayer in that matter before the honorable bench, the Supreme Court.
Application was dismissed on 11th.
This was at, yes, my lords. I am so grateful. That order, my lords, will find at page number 29. the Supreme Court refused to entertain that. So, my lords, even there, it attained a finality. My lords, it has been really ongoing. Now, please come to page 31. This is very important. This was again a writ petition filed by certain B.Ed chhatra. Now, these were B.Ed candidates before the Honorable Supreme Court. See their prayers at page number 32. Issue a writ that all recruitment process for post of primary elementary teachers commenced on the basis of NCTE notification dated 28/6/2018 prior to the judgment, my lords, to complete and appoint the selected candidates, then directing respondent to consider B.Ed candidates who are eligible to recruitment. Now, if my lords may see,
The date is
and they
important.
also gave they gave an undertaking to do the bridge course, and this is filed on 6th of January 2024 after the judgment in Divesh. Would my lords now turn to page number 34 at 35, please? Excuse me. My lords, please see this. In this matter, the order is at page 35. In view of the fact that pendency of some of the connected matters are not disclosed in the instant writ petition, we permit the petition to be withdrawn with a cost, and they dismissed it as withdrawn without granting them any liberty at all to file a fresh petition. Because, my lords, this same party, people, had also filed a petition which had already been rejected by the court. So the court took a very serious note of that and said, okay, we'll allow you to withdraw it with cost, with no liberty to file. Now, my lords, again, in another batch of matters, if my lords may come to now page number 37, some of the miscellaneous applications for clarification and directions, again in Divesh Sharma, and please see the Supreme Court order, similar position.
We directly come to 40. We can directly show High Court.
Yes. Now, my lords, this was also came to be withdrawn. I've already shown you many of this. It is not necessary. Now, see Patna High Court. My lords, before Patna High Court, these matters were agitated again. And please to see the view that Patna High Court takes. Would my lords be so kind and take first page number 50 before the Patna High Court?
Starts at 40 at 50.
50. There were interveners before Patna High Courts who were B.Ed candidates. So I wanted to show those two paragraphs of facts and take you to the findings straight away. Paragraph 7, my lords. Interveners who support the cause of B.Ed candidates are before us. Despite the pendency of the writ petition having been communicated to appointed candidates as vouched by government advocate, none except the interveners have sought impleadment in the writ petition.
Chief Justice has it. My lord, the Chief Justice has it. The page?
Yes, yes. Yeah. I'm on para number, space 62, para number 24.
Yes, my lords, I am so grateful. 62, 63. I'm grateful, my lords. So, my lords, after noticing it is no longer, please, yes.
ठीक है, चलिए आप लोग बताइए
भाई.
My lords, there is Uttarakhand also.
We have followed.
My lords have already seen it. That's one page order. So, my lords, I say that this issue is now completely settled. And my lords, only, can I just point, my lords, only one thing may I say before the other side starts in this, and I think it is of some importance.
Yes.
Now, my lords, out here, there were a total of 40,000 vacancies, 4,000 vacancies. In 2023, that advertisement which is challenged before my lords, there were 6,285 vacancies. What I want to bring to my lords' notice is after the judgment of the Honorable Supreme Court, people with B.Ed have been appointed, which could not have been done. Even before it could not have been done because the qualification had been quashed. So these appointments definitely could not have been done, and these have been done. 2,100 have been appointed after the judgment. The qualification is no longer a valid qualification for the purpose of the post of primary teachers, my lords. So, my lords, I submit that these have to go.
Just to add on, figures is 10,300 is the total vacancy till today, 10,300. And out of that, 5,300 are serving. So those 5,300 have to be out because they are ineligible. just the figures, my lord, we wanted to assist. 10,300. As per 2019, vacancy was 4,000. As per 2023, vacancy was 6,285. Total 10,300. And out of these 10,300, 5,300 are B.Ed candidates who are on the post. So therefore, they need to be taken out as per the Supreme Court judgments held multiple times.
Have you made any amendment in your petition for that?
Well, their appointments are subject to the outcome of the writ petition. Their appointments are subject to
लिखा है क्या?
yes,
लिखा है क्या?
yes,
Yes,
Very
yes. My lords, that was the order that was passed
only
by this
one
court
fact I want
itself.
to bring, my lord. Page number 25 in my case, that is next case, my lord.
आपका कौन सा है श्रीवास्तव?
Next case, my lord.
इसमें तो मैंने
5788. Because as per my submission, my lord, even the rule are not required to be challenged now. Page 25 में can you look?
आपका कौन सा है श्रीवास्तव?
Next question.
एक सेकंड. हाँ श्रीवास्तव.
So, my lord, may directly come to page 25. It is a part of the rule.
Page 25.
Yes, ma'am.
इसमें आपकी प्रेयर एक मिनट देखिए श्रीवास्तव. हाँ. आपका भी वही सेम प्रेयर है प्रीवियस वाले के साथ.
Page 25 में can you look?
Page 25. जी page 25 आ गया.
Roman 3 में can you look?
Roman 3.
It is a part of the rule. Educational qualification and experience. The candidate must possess the educational qualification and experience as prescribed for the service as shown in column number so and so for primary education. This is the relevant, my lord, now. The prescribed qualification will be applicable as per the provisions of the right to free and compulsory education 2009. Now, so far as that qualification, this is the provision with regard to the legislation by incorporation, my lord. This provision is under the principle of legislation by incorporation. That provision with regard to the applicability of the B.Ed that has been set aside and quashed by the Rajasthan High Court on 25th of 11/2021. That was not set aside, stated by the Honorable Supreme Court. So that particular provision remained inoperative, my lord, on the date of 4th of May 2023 in view of this clause.
ठीक.
So advertisement itself is contrary to their own rule.
ठीक. अब आप लोग बताइए प्लीज.
Senior counsel is connected, your lordship.
हाँ राइट. आप वाला इसी में इंटरवीनर हैं आप. किस वाले में फाइल किया आप लोगों ने?
Serial number 2 में, your lordship.
इसे इसी श्रीवास्तव. ठीक है. Yes, Mr. Srivastava, just let us know what is your. बताइए.
So I thought the state will also have to say something, but I can, my lords, I can definitely assist your lordships, but the state is also party in this case. What are they to say? But I can start, my lords, if that is.
State बता दीजिए.
No.
Yes.
Your lordship, the selection process.
My lords, I am appearing, with great respect, my lords, I am appearing in Vikas Kaushik's matter, which has been argued. That is WP number 5788 of 2020.
Implement डाल रखा है.
Implement डाल रखा है. ठीक है, ठीक है.
Now, this is, my lords, a case in which, with great, my lords, your lordships were kind enough to implead us as the respondent, my lord, party respondent, as per the orders of the Supreme Court. So we are impleaded respondents, my lords, and we represent, and we are B.Ed candidates who have been selected and who have been appointed.
Right.
Under the orders of the Supreme Court. Now, my lords, I wish to say with greatest respect, my lords, and with all humility, that the matter is neither, my lords, the matter is neither very easy nor very simple, my lord, as has been sought to be impressed upon your lordships, my lords. And I wish to make a submission with greatest respect, my lords, is this, that what is binding on your lordships today, my lords, while this matter is being decided, are the Supreme Court, my lords. Of course, Devesh Sharma's judgment is there, my lord. To what extent that concludes the matter or the controversy, my lord, is yet to be seen by this honorable court. And, my lords, if there is any order passed by this High Court, my lord, then only it will be binding. Others have only, my lord, some persuasive value. Now, I wish to say, my lord, except one order of the Supreme Court, the issue as to whether Devesh Sharma's judgment, my lord, applies to the pending advertisements or advertisements which have been issued, my lords, prior to the date of the judgment has not been gone into, my lord. With greatest respect, I make this submission. This issue is absolutely open before your lordships, my lord. It has to be decided. Now, my lords, may I request your lordships to have my compilation. I have also prepared a compilation, my lords, giving all the necessary sequence-wise, all the necessary notifications, etc. May I request my learned colleague, Mrs. Naushina Ali, to hand over the compilation to the Honorable Court and the opposite side. This is called convenience compilation.
Convenience compilation.
I have my own convenience compilation, my lords. There will be no, these are all matters of either the notifications, rules, or the judgments, orders.
What is that? That is the convenience compilation. Yes.
Yes. The lordships may make a mark, my lord. Convenience compilation submitted by Ravindra Srivastava, my lords. That is how your lordships will please distinguish it. Now, if your lordships are pleased to turn to page 148, my lord, I wish to begin page 148.
Yes.
Please see, my lord, this is the Sharma judgment. Please note the date on the bottom of the page, 11th August 2023. That is the date, and that's a very crucial date. Now, thereafter, my lord, after this judgment was rendered and the recruitment had already concluded, except that the appointment orders were to be issued in Chhattisgarh. Page 149, my lord, is the order that your lordship had the occasion to pass in Vikas Kaushik's case. And my lords, I wish to make a correction of the fact which was mentioned on the last date of hearing, that in Devesh Sharma, Chhattisgarh was a party. I'm sure, my lord, the instructions were not properly given to the senior counsel. Chhattisgarh state was not party in Rajasthan case, my lord. This is a matter of a record and it may be verified. It was absolutely incorrect statement that was made, my lord. I don't know what was the purpose. Now, your lordship's order at page 150, my lord, is 21st of August 2023. I'm just trying to show how the issue is open, my lord. It is not concluded. The third paragraph, learned counsel for the petitioner submit that earlier, DED candidates were allowed for appointment on the post of assistant teacher, but by notification dated 23rd August 2018, NTC has also included B.Ed at par with DED for appointment on the post of assistant teacher, and accordingly, state of Chhattisgarh has also included B.Ed. But the Honorable Supreme Court in recent judgment in so that is, they held that only DED candidates are eligible for appointment on the post of assistant teacher, and inclusion of DED qualified candidates is illegal and quashed the notification. And accordingly, rules of the state of Chhattisgarh regarding inclusion of DED candidates has also to be held as far as he therefore paid for staying the recruitment process. Considering the arguments advanced by learned counsel for the parties and also considering the law laid down by the Apex Court on the issue in question passed in civil appeal number so and so, the further recruitment process with regard to the candidates having DED qualification for the post of assistant teacher shall be kept in abeyance with immediate effect, and further no final decision would be taken by the respondents in respect of such candidates till the next date of hearing. So not that your lordships have completely debarred them, but a final decision is required to be taken in regard to the B.Ed candidates. Now, my lord, the matter went to the Supreme Court, and this is the only order, my lord, in Chhattisgarh, which is there with, my lord, to guide your lordships. And with greatest respect, my lords, will bind also. Page 153, order dated 29th of August 2023, against the order that your lordships were pleased to pass. Now, kindly read this order, my lords. And this is how the matter is open. In the meantime, taking into consideration that the recruitment process which was in progress is now interrupted by the ad interim order dated 21/8/2023, and the aspect ultimately to be considered by the High Court is with regard to the manner in which the judgment in CA number so and so, Devesh Sharma, passed by this court is to be construed at this stage interrupting the recruitment process would not be justified. So, my lord, your lordships are required to constitute the judgment in David Sharma case. Therefore, to the extent we hereby state the order dated 21/8/2023, passed by the High Court and clarify that the recruitment process which was in progress prior to the date of the said interim order passed by the High Court shall continue, and the appointments, if any, made thereunder will, however, remain subject to result of the consideration to be made by the High Court in WPs. The selected candidates will be informed by the appointing authority. In the meantime, notwithstanding the pendency of these petitions, the petitions herein may implead themselves before the High Court in the writ petition if the High Court deems it fit to hear the parties and consider the writ petition on its own merits and in accordance with law. There shall be no impediment for the High Court to proceed on merits in matter, since these petitions are limited to the aspect of the interim order. Now, my lord, this order operates, my lord, even till date. The matter was listed before the Honorable Supreme Court a day before, that is on, my lords. My lords, frantic efforts have been made, my lord, by the opposite parties to have this stay order vacated, my lord, but they have not succeeded. So, my lord, my submission is that in terms of this order, your lordships are, my lords, required to constitute David Sharma's judgment, my lords, as to whether the B.Ed candidates for this year under the advertisement of 2023 are required to be eliminated. May I therefore, my lord, take your lordship to my lord's page 147 of the compilation, my lord, that is, my lord, very intelligently has not been placed before your lordship, my lord, on which the Honorable Supreme Court in this order which I read, my lord, has called upon this court to constitute the order, the judgment. This was a case, my lord, this Rajasthan case, my lord, when they ultimately, and probably, my lord, proverbial use of the expression where, my lord, the surgery succeeds, my lord, but the patient dies. They did not get any relief in Rajasthan case. In Rajasthan case, my lord, under the advertisement for the current year, B.Ed candidates have been appointed under David Sharma's judgment. Why? Because kindly see what the Supreme Court says now here, my lords. And this has not been shown to your lordship so far, which we showed to the Supreme Court, and Supreme Court was, my lord, appreciated and passed the interim order. Having made the above determination, namely, having made, my lord, page 147.
Yes, having made, yes.
Page 147. My lord, this is a continuing paragraph 36.
Page 140, the entire exercise.
Yes.
Yeah, yes.
Yes. Having made the above, and this is what, my lord, we rely upon. Either, my lord, I will succeed on this or I will fail on this, my lord. My case is very short. Having made the above determination, we at the same time are also of the considered opinion that the state of Rajasthan was clearly in error in not calling the application from B.Ed qualified candidates. My lord, I must pause here. The facts in Rajasthan case were there, that under the Rajasthan advertisement, my lord, the B.Ed candidates were not called, notwithstanding the fact that under the notification 28/6/2018, my lords, B.Ed candidates were eligible. For the reason that till that time when such an advertisement was issued by Rajasthan government, B.Ed candidates were included as eligible candidate as per the statutory notification of NCTE, which was binding on Rajasthan government, till it was declared illegal or unconstitutional by the court. The Rajasthan High Court had rightly observed, my lord, the Rajasthan High Court itself, my lord, gave relief to B.Ed candidates. We are of the opinion that the state government could not have ignored the notification while inviting applications for REET, even if the state government was of the opinion that such notification was unconstitutional or for any reason illegal. The same had to be stayed or set aside by a competent court before it could be ignored. Para 45. What the Rajasthan High Court had stated above is a settled legal position. In a recent judgment of the court in the state of Manipur versus so-and-so, this position that is statute which is made by a competent legislature is valid till it is declared unconstitutional by a court of law has been reiterated. Consequently, the appeals are dismissed and judgment dated 24 so and so, so and so. So Rajasthan High Court, despite holding, my lord, that DEDs are not eligible.
What was the fate of the persons who were called for, applications were called for and they had qualified? What happened in that case?
They did not get the appointments.
No,
They
no,
did
no,
not
sorry,
get
sorry,
the
sorry, sorry.
appointments.
No,
They
no,
did not
sorry.
get the appointment.
My lords, I
In
appeared in that
no, please,
Rajasthan
please.
matter.
In Rajasthan matter, the B.Ed candidates, because of para 36, my lord, the two paragraphs which I have read, and the High Court's own judgment have been appointed where qualified.
No, that's completely incorrect statement, Mr.
Let's
Srivastava. You have
contest
not
the
been
law. Let's-
instructed properly. May
All
I
right.
just show
No,
Mr.
just-
Srivastava?
Madam, please don't interrupt me.
Let him
Madam,
complete
please
first.
don't
Let him
interrupt me.
complete. Let him complete.
My submission, therefore, my lord, as to
Mr. Srivastava, just tell us what happened, page 147, you have said that the observation of the apex court, what happened to that B.Ed candidates who had qualified, whether they were ousted or they are still continuing?
where my lord,
What are your instructions? What are your instructions?
my lord, in Rajasthan or Chhattisgarh?
Rajasthan, you are saying na, that the Rajasthan High Court, they have participated and they were qualified candidates. Whether they got the appointment or not. That is what we are asking you.
My lords, I will get, my lords, my instructions were that they were then in compliance of the Rajasthan High Court judgment and the Supreme Court judgment were called, and my lord, they will. But my lord, I will again get back to you. I will again get back to you since it is being disputed, and will, my lord, inform your lordship, my lord, as to what the correct position is.
आप लोग बताइए, आप लोग को बताओ.
They have preferred their petition, my lord.
Because when they
वो oust हो
filed,
गए थे.
no. The reason where they filed the petition before the Rajasthan High Court was precisely on the ground that they were not being allowed to participate in
नहीं,
the
वो तो allowed
recruitment
है, तो
process.
उन्होंने कहा कि इस समय इनको आप क्या
तो
कहते हैं,
करिए.
परमिट करने के लिए कहा.
Before the Rajasthan High Court, the issue was that D.Ed candidates had challenged that the B.Ed candidate should be ousted.
Outside, हाँ.
And Rajasthan High Court said the Rajasthan government was justified because till the notification was there, the Rajasthan government could not have ignored that notification of inclusion of the
नहीं, तो
B.Ed.
finally, what was the fate of those persons?
Yes.
We want to know.
May I point out?
What was
My
the
lords,
fate? What was the
yes.
fate?
My lords,
The qualification of B.Ed.
हाँ, वही तो
They
उन्होंने
have
तो
not been called. Rajasthan government has not called those persons in the examination. They are not allowed.
अच्छा.
They are
No.
therefore filed a writ petition,
हाँ.
and other candidate of the B.Ed also filed a writ petition before the Rajasthan High Court.
हाँ.
101 of the Melody serial
My lord,
number.
I'll just minute.
my lords, I have the paragraph
I
of the
will-
Rajasthan High Court judgment.
But the fact remains, my lord, as a matter of law.
Judgment
My lord,
protects
my learned
My
friends.
lord, kindly see the facts.
Can I argue or can I not argue? Madam,
Mr.
Hey,
Srivastava, can I
102.
only show the
no,
paragraph
I
of
did not
Rajasthan High
interrupt
Court
you.
judgment?
Madam, I did not interrupt you.
Paragraph 1 minute.
हैं?
The judgment passed by the Honorable Rajasthan High Court minute. Paragraph number 1.
Paragraph 53, paragraph 53, the last paragraph.
Paragraph 2.
नहीं नहीं,
says
एक
the-
सेकंड. ऐसा है ना कि जो श्रीवास्तव साहब ने कहा ना कि
Paragraph 2 shows
वो
the
आप
cause of action.
पैरा
Paragraph 2 shows the cause of action before the Rajasthan High Court. Where it says that the B.Ed holders had filed a writ petition of their exclusion. There are two sets of it.
My lords, paragraph 53. Paragraph 53, the last paragraph.
But para
There was
45 has been approved by the Supreme Court. Para 45 has been
Can I,
approved.
एक
No,
सेकंड,
I'm
एक
on
मिनट होल्ड
my
ऑन.
list.
भाई आप लोग तो
I'm
ऐसा
arguing.
बना देते हैं ऐसा.
You will have, madam, rejoined a chance of rejoinder.
एक सेकंड,
But it's a question posed, Malad. Page 135 of Bhuneshwar Sahu has para 53. Page 135 of Bhuneshwar Sahu has para 53. It is the answer. That is a question that my lords are posing and we are giving that answer.
I will answer that. Bhuvneshwar Sahu, I will answer. Don't worry. I will answer
Just see
that.
that for a minute, sir, if you don't mind. Just see that.
No interruption, please. Mr. Kala, please don't interrupt.
Just wait, just भुवनेश्वर साहू का जजमेंट किस वाले पेज पे था?
Bhubaneswar writ petition serial number
In
1.
Bhuneshwar Sahu, page 135.
Serial number 1 minute.
सीरियल नंबर, हाँ नहीं, वन उस पे क्या दिखाना चाहे पैरा
Page 135, para 53.
Paragraph 53, where the Rajasthan High Court, where the interim order were passed, that has been vacated and they have been excluded.
कहाँ पर है, वही देखना चाह रहे हैं.
We just want to be clear on facts. That's all.
153.
153 page number.
135, para 53. Page 135, para 53. If I may read.
135.
135.
Para 53.
Para 53, the interim order granted.
Allowing
the
the-
petition
हाँ ये है तो यही तो है
are vacated.
तो उनका तो कोई रिक्रूटमेंट हो ही ना होगा
नहीं हुआ sir.
No, they
They-
have not been
they did
recruited,
mention
my
the
lords.
Supreme
None
Court
of them have been
also.
recruited.
Status of the that Devesh Sharma having the qualification of B.Ed.
वो तो कर ही नहीं सकते थे ऐसे तो नहीं कर सकते।
My lords,
Yes,
can-
Mr. Srivastava, please continue. हाँ
Yes. Now,
ठीक है देख वाले उनको
Sir.
बोल देंगे। हाँ yes, Mr. Srivastava, ठीक है आपने उनको
Yes,
पढ़ाया।
Now, my lords, therefore, I will stand corrected, my lord, if my instructions were not correct. But the fact remains that the nuance of this paragraph 36, which I read, my lord, the two paragraphs, is this that until the rule or the advertisement has been set aside, they remain valid. It is binding on the state government because they are statutory. And the recruitment is required to be conducted as per, my lord, the existing rules and the advertisement. I will show a direct constitution bench judgment of this point, my lords, little later. But please have, my lords, for the time being, only few dates, which are telling, my lord, and which distinguish. Because I'm also relying upon Devesh Sharma, though on the last penultimate two paragraphs. Now, may I request Mrs. Madam Naushina Ali to give the written submissions, my brief points of submissions, please.
ये वाला ना?
Yes, yes.
This one ना?
Brief points, the first one. मैंने compilation एक दिया हुआ है, Your Lordship.
ये वाला, this one.
Brief, उसमें brief points of submission है.
हाँ ये yes, Mr. Srivastava, we have.
I shall very quickly, my lord, place these submissions, my lords, to short the time. Now, my lords, may I read at the outset the petitioners, my lord, that is the D.Ed candidates, have no locus or cause of action to file the writ petition and seek relief as prayed for want of legally enforceable right in their favor. In the select list, petitioners are way below, even if the B.Ed candidates are struck off from the select list, as contended by them, the impleaded respondents submit on the basis of instruction that the petitioners stand no chance of being appointed by as assistant teacher. Curiously, the petitioners have not disclosed their position in the select list. And my lords, my learned friend, colleague, Mrs. Ali will assist with the select list, my lords. Will show that some of the petitioners are not there in the select list. Some of which, my lord, Vikas Kaushik are below, my lord, even beyond 6,000. The existing vacancies are 6,000. Now, my lord, point number two, my lord. The submission of the petitions that the issue pending before the Honorable Court is covered in their favor to eliminate the B.Ed candidates from recruitment is entirely incorrect and seriously refuted. Further submission that Honorable Supreme Court had dismissed all the cases IAs filed by the B.Ed candidate is even more incorrect and untrue statement of fact to prejudice this Honorable Court. It is emphatically denied. There are cases and IAs pending before the Honorable Supreme Court, including the review petition against the main judgment in Devesh Sharma's case. The true and correct position is reflected in the chart prepared by the impleaded respondents. It is a completely incorrect statement that the state government of Chhattisgarh was a party in the Honorable Supreme Court in Devesh Sharma's case. The petitioners are entirely misleading Devesh Sharma's misleading. I'm sorry, my lord, I stand corrected. I didn't want to say misleading, my lord. I want to say misreading, my lord, misreading.
Right.
Are entirely misreading the Devesh Sharma judgment, my lord, of the Honorable Supreme Court to house the impleaded respondents B.Ed group from the current recruitment and appointment to the post of lecturer, teacher, so and so. The petitioners are outrageously suppressing the fact which is apparent on the face of the judgment of the Supreme Court that the notification issued by the National Council for Teacher Education dated so and so was binding on the Rajasthan government till it was invalidated. Consequently, both the Rajasthan High Court and Supreme Court have held that Rajasthan government was not empowered and otherwise acted illegally in not calling the B.Ed candidates for recruitment and appointment as per the notification dated so and so. The Honorable Supreme Court has held that Rajasthan government was bound to follow the notification. Well, the relevant paragraphs I have already read. This dictum of the Honorable Supreme Court clearly applies to the facts insofar as the recruitment in the state of Chhattisgarh is concerned. Now, my lord, here I give you to your lordships a chronology. The Chhattisgarh School Education Service Education Administrative Cadre Recruitment and Promotion Rules 2019 are framed by the Governor, while notification dated 5/3/2019. So the rules are framed in 2019. These rules, my lords, include, I will just now show from the compilation, B.Ed candidates, my lords, and your lordships will please appreciate these are the independent rules framed by the governor under Article 309 proviso to the Constitution. The rules have been framed by the governor regulating recruitment to civil services. The state government commenced the recruitment by publishing the advertisement dated 4/5/2003. So please note, my lord, the date of the advertisement as 4th of May. Devesh Sharma's judgment, my lords, which becomes law under Article 141 on both aspects, is 11th of August 2023 on the date, my lords, and I am absolutely horrified when it is argued, my lord, to hear that when it is argued that the advertisement on the date of advertisement, it was just now said to your lordships, my lords. It was just now said to your lordships, my lords, and shocking to me that on the date of the advertisement, my lord, the notification is struck down, which is, my lord, incorrect. This advertisement dated 4/5/2023 has not been called into question by anyone at any point of time. My lord, the rules, my lord, have not been challenged. The notification advertisement has not been challenged. The state government published the result on 1/7/2023 before Devesh Sharma judgment. The Supreme Court pronounced the judgment on 11/8/2023. The Honorable Supreme Court only dealt with the validity of the notification 28/6/2018 issued by the NCT. The Honorable Supreme Court was not dealing with any challenge to the recruitment rules framed by the governor under Article 309 of the Constitution and the advertisement issued pursuant to. As per order of the Supreme Court in SLP in Harishankar, my lord, that I read to your lordships, having appreciated the fact that B.Ed candidates could not even excluded candidates as per the dictum of Supreme Court in Devesh Sharma, issued interim directions staying the operation, my lords. I need not repeat it. Then come to para 6 at page 6. The order passed by the Honorable Supreme Court.
देखिए, Mr. Srivastava, we have followed what you want to convey.
Just 1 minute, my lord. Please bear with me. The order passed by the Honorable Supreme Court dated 28/8/2023 in Bhagwan Krishna, arising out of the state of Bihar, to the extent of the notification dated 28/6/2018 being set aside of the Devesh Sharma, the position of B.Ed candidates Chhattisgarh is not affected, much less worsened off. It is clear from the order that repetition in Bhagwan Das has been allowed only in terms of judgment passed in Devesh Sharma. It would clearly therefore mean that judgment would apply with the caveat in para 36 that the advertisement already issued on the recruitment commence prior to the date of judgment would not disqualify the B.Ed candidates. This is the contention of B.Ed candidates in Harishankar, which prima facie found acceptance of the Supreme Court interim order dated 29/8/2019. Now, my lord, in this case, Bhagwan Krishna, what the Supreme Court says is this: the petition is allowed to the extent of the Devesh Sharma's judgment. Now, Devesh Sharma's judgment is in two parts. The first part is the legal enunciation, my lord, that B.Ed candidates are not to be treated. The second part, my lord, which is as much applicable under Bhagwan Krishna's judgment orders, my lord, is that so far as the advertisement already issued is concerned, and B.Ed candidates, according to the statutory notification, were eligible, till it is struck down, my lord, they will be treated as eligible, which is the position. So Bhagwan Krishna helps me, my lords. It is in my support that you have to apply both, my lord, the Devesh Sharma judgment while holding that B.Eds are not eligible. My lord, Bhagwan Krishna does not say that para 36, where, my lord, the advertisement already issued will have to be protected, is to be ignored, my lords. Then para 7, that the above narration of facts in the light of dictum of Supreme Court, that Devesh Sharma's case cannot be pressed into service by petitioners to hold that hundreds and similarly situated persons were not eligible or did not possess academic qualification. That the governor of Chhattisgarh in exercise of power under Article 309 has framed rules, my lords, which were published in Gazette dated 5/3/2019. It was subsequently amended by notification 4/5/2023. The rules are amended to prescribe statutorily academic qualification for appointment as various, my lords. We are 2,000 people, my lords. After the Supreme Court
दो
order,
हजार का appointment हो चुका है.
That is after the order of the Supreme Court.
yes, 2,000 people have been appointed. There is still vacancies of about 2,000, my lord. The total appointments is still vacant.
Mr. रघुवर दयाल कि जैसे कि मैडम ने दिखाया अभी कि जो है उन्होंने जजमेंट के पहले का कहा कि नहीं इफेक्ट, वो सुप्रीम कोर्ट ने रिजेक्ट कर दिया. कहीं ऐसा कोई सी भी हाई कोर्ट का या सुप्रीम कोर्ट का ये है कि जो लोग ऑलरेडी कोई अपॉइंटमेंट किसी का नहीं हुआ था, यहाँ तो हो गया है, यहाँ आफ्टर सुप्रीम कोर्ट जजमेंट. हाँ हाँ
The selection list was there.
हाँ हाँ
There no such appointment was made at that point of time.
हाँ हाँ.
They were reached on
सुप्रीम कोर्ट ने तो इनको कहा कि आप सिलेक्शन प्रोसेस गो ऑन करिए, हेल्ड अप ना करिए.
And their appointment shall be
सब्जेक्ट टू द डिसीजन ऑफ दिस पिटीशन. यही है. That is-
But at the same time, Lordship, if I may be permitted,
No, sir,
when
right.
Arnab Ghosh had moved an MA before the Honorable Supreme Court, Your Lordship, in that also there was a prayer that the Supreme Court was of the view that candidates who have already been appointed and they have not been ousted, they are not before us. So therefore, we are not making any comment on that. They simply, the Arnab Ghosh wala case जो था वो
मैडम
withdraw हो गया.
देखिए, एक चीज आप लोग को बताए ना, जो रेशियो देवेश वर्मा में lay down किया कि this is unconstitutional, this cannot be done,
That is
right?
जी.
After that, we will permit this.
But then how can it be applied retrospectively?
No, no, no.
Because it is not mentioned
Retrospective,
in that
prospective,
particular
the
order.
Supreme Court has said no. That is all.
Let's do like that.
चलिए ठीक है. It is मतलब जो हम लोग को अभी तक ये लग रहा है.
Jan case is already
Right.
prior to the judgment of the
हाँ,
Supreme Court.
आप बताइए श्रीवास्तव, अब आप बता दीजिए, उधर हो गया. चलिए ना.
Lordship, this
अब मिस्टर श्रीवास्तव, नाउ वी हर्ड राजीव श्रीवास्तव साहब. सेम आप लोग का बस वही केस है ना, जितना है कि आपका ये कहना है कि जो देवेश शर्मा का जो केस है.
wants to say something. Your Lordship.
यस मिस्टर श्रीवास्तव. हाँ प्लीज बताइए श्रीवास्तव, बताइए. यस मिस्टर श्रीवास्तव.
Yes, Lords, now, my lords, it's just now what fell from the lordships, my lords, that if Devesh Sharma has held that it is unconstitutional, my lord, there is always, my lord, a very well settled
बस
theory of
अब आपका
prospective
ये है कि
overruling.
आपका इसका रेट्रोस्पेक्टिव इफेक्ट है ना कि प्रोस्पेक्टिव इफेक्ट. दिस इज व्हाट
वही
टू
Supreme
पीपल से दैट
Court
कि
has
अभी
करने के लिए.
आपको जो परमिट कर दिया तो आप लोग का अपॉइंटमेंट हो गया, वेदर दैट कैन बी सेट असाइड एंड दीस पीपल विल बी आस्क्ड टू जॉइन और नॉट. दिस इज योर मेन कंटेंशन इज.
My
Because prior to
suggestion-
Devesh
By
Sharma,
so far as Devesh Sharma's ratio which has been led, you have nothing to say.
because ratio जो
I
later हुआ
don't
है
want to
तो
say
नए
that,
एडवर्टीजमेंट जो 11/8 के बाद आए
नहीं
हैं उसको
नहीं,
इफेक्ट
वो
करेगा.
आपकी बात वो सही है, बट जो उन्होंने बेसिक चीज तय की कि बीएड और डीएड के बीच में प्राइमरी एजुकेशन में है कि बीएड हैव नो रोल, डीएड हैव. दैट इज व्हाट उन्होंने ये होल्ड कर दिया.
Position is
Devesh
this,
Sharma
Lord.
has also protected the
No,
B.Ed
then I-
candidates have taken.
नहीं नहीं, अब
And-
आप हमको एक इंस्टेंस से आप ये भी दिखा दीजिए कहीं भी कि बीएड कैंडिडेट आफ्टर दिस जजमेंट
Yes,
आर स्टिल वर्किंग. आप हमको इतना दिखा दीजिए.
My lord,
Right?
can I- my lord,
Argument have no
can I-
end.
can I-
You go on argue irrespective, वो कहीं उसका कोई अनएंडिंग प्रोसेस है.
मालूम.
लेकिन हमको बस इतना ही दिखा दीजिए. बस इतना ही आप लोग को है दिक्कत कि आपका अपॉइंटमेंट हो गया है. Supposing we are of the view that in view of this judgment, you have nothing, you will have to go.
मालूम.
Right? But you are harping upon us that this notification which was issued and this was caused, that वो notification still survived. 11/8 का वो आया नहीं था, उस बीच रिक्रूटमेंट प्रोसेस हो गया. यही आपका है बेसिक चीज.
जिस दिनांक एडवर्टीजमेंट आया
हाँ,
था
वो उस दिन
28
था.
2018
This is what, यही आप लोग का है. अब this is what we have to also examine.
जी.
कि ये कितना हद तक वो है कि नहीं.
That is why I am
No,
allowed.
my lord, please, Mr. Rajiv, my lord, I'm still arguing. I mean,
हाँ, एक से मिस्टर श्रीवास्तव. हाँ, ये आप ये श्रीवास्तव आप सुन लेते हैं.
Yes,
हाँ,
my
yes,
lord.
मिस्टर.
now, my lords, I wish to give to your lordships one or two decisions on the point,
जी
my
जी.
lord, which I support my contention. My lord, Mr. Sally, can you give the case
कौन
note
सा
that
है?
I case note?
पेज
केस नोट नौशीना जी जो आज सुबह आपने आपको भेजा है.
क्या भेजा?
केस नोट्स योर लॉर्डशिप
Case
एज दिस
note.
बात. केस नोट योर लॉर्डशिप.
ये वाला.
My lord, what you do is, my lord,
एक
no,
से
it
एक
is
से
not
मिस्टर श्रीवास्तव देख रहे हैं. वी आर जेनेसिस. हाँ, केस नोट मिल गया. यस.
दो सेट्स में है ये.
हाँ, ठीक है, मिल गया.
my lord, so it is the heading is rule making power. My lord, see the 1993 SCC 157 para 11.
SCC. कहाँ है?
Page
1990.
157 para 11.
Even Shetty.
Is it there, my lords?
हाँ, yes,
1990.
we have Mr. Srivastava. ये है
Yes,
मिल
there is yet another aspect.
हाँ प्लीज बताइए कौन सा पेज पेज बताइए प्लीज
Page
My
number
lords,
1.
para 11.
Page number 1.
Case note para 11, my lords.
पैरा अच्छा
The
पैरा
top
11
page, top of the
जी
page.
जी पैरा 11 जी पैरा 11
The top of the page, well, we have expected the para so that your lordships are para 157. Can your lordships have the first page of the case note, my lord, where it is there is a case note, madam, is it not there, the covering page?
हाँ 157 बोल रहे हैं पेज 157 इज रेफरिंग मिस्टर श्रीवास्तव
157. Para.
जी बताइए बताइए प्लीज बताइए
Yes, there is yet another aspect of the question where advertisement issued in writing applications for direct recruitment to a category of posts, and the advertisement expressly states that selection shall be made in accordance with the existing rules of government. And if it further indicates the extent of reservation in favor of the selection of the candidates in such a case must be made in accordance with then existing rules and the government orders. Then existing rules. Candidate who apply and undergo written or viva voce test acquired vested rights for being considered for selection in accordance with the terms and conditions contained in the advertisement vested rights, unless the advertisement itself indicates a contrary intention. Generally, a candidate has right to be considered in accordance with the terms and conditions. Out in the advertisement, right, crystallizes on the date of publication of the advertisement. However, he has no absolute right in the matter if the recruitment rules are amended retrospectively, which is not the case. Then, my lords, kindly skip a little below. The legislative intent is ascertained either by express provision or necessary implication. If the amended rules are not retrospective in nature, the selection must be regulated in accordance with the rules and orders which were in force on the date of the advertisement. Then, little below, but if he is eligible and is otherwise qualified in accordance with the relevant rules and the terms contained in the advertisement, he does acquire a vested right of being considered for selection in accordance with the rules as they existed on the date of advertisement. He cannot be deprived of that limited right on the amendment of rules during the pendency of selection process. The amended rules are retrospective in nature. Then, my lords, kindly skip below. Listen, the underlying portion, bench of this court rejected the contention holding that since the whole procedure of issuing advertisement, holding interview, and recommending the names, having been followed in accordance with the then existing rules, prior to enforcement of the amended rules, the appointments made on the basis of the recommendation made by could not be rendered invalid. Then, my lord, the quoted portion from the judgment in Rangaiya, the vacancies which occur prior to the amended rules would be governed by the old rules and not by the amended rules. Then, my lords, again, this judgment, Ganeshwar versus State of Andhra, which is quoted in the, it is a well-settled, accepted principle of construction that is statute rule or government order is prospective in nature unless it is expressly or by necessary implication made to have retrospective effect. Where proceedings are initiated for selection by issuing advertisement, the selection should normally be regulated by then existing rules and the government orders, and any amendment of the rules and government orders pending the selection should not affect the validity of selection made by the selecting authority or the Public Service Commission unless the amended rules are so and so. Then there are the next judgment is Bhatnagar, A.K. Bhatnagar, 1991, 1 SCC 544. And I will only read para 13,
we will go through this judgment. We have followed. Chaliye, judgment.
And the third is a constitution-based judgment, very important.
We will go through case notes and all.
So, my lord, if the lordships really constitute, my lord, para 36,
yes.
page 147, two paragraphs. The Supreme Court's intention was that so long as the rules are not invalidated, the rules remain operative and they are required to be followed, they are binding, and that is how, my lord, we are protected. The invalidation has taken place only on 11th of August. That is the short point. Now, my lord, B.Ed candidates, my lords, we as the B.Ed candidates, the David Sharma's judgment, my lord, I will only give the page, my lord, the page, where the background is this, that this body, Kendriya Vidyalaya, the Lord institution, moved a proposal to the authorities, my lord, Union of India, that sufficient number of diploma candidates, which are supposed to be more qualified or better suited for teaching the primary schools, are not available in India. It is in this background, my lord, that 28/6/2018 amendment was made by, my lord, directed to be made by central government and by the NCTE. So it is a matter of recording the judgment that sufficient numbers are not available. Now, please imagine a situation today, my lords. There are 6,000 vacancies, and we are dealing with only government schools or government-aided schools. If, my lords, only my lord, less than two, my lords, about 2,000 my lord, diploma are to be, my lords, only appointed, 4,000 and odd vacancies will be there. What will be affected? Is it in public interest, my lord? Is it in the interest of the primary education? There will be no teachers in the school. There will be the teaching will be affected. Now, my lord, B.Ed, my lord, the law itself, section 23 contemplates, my lord, if I can please have the, my lord, that will have an important bearing on your lordship's appreciation, my lords. Give me the Act 23. Section 23, my lord, please have a look at, my lord, this. I'm not arguing against David Sharma, my lord, but there is a lot in the review petition to argue in David Sharma. It has gone against the specific statute. Section 23, my lord, just have a look at it. The intention of the parliament and the David Sharma judgment on the other side. Section 23. Lordship's getting it, lords?
हाँ मिल गया.
Qualifications for appointment and terms of conditions of teachers. Any person possessing such minimum qualification, so they talked about minimum qualification, as laid down by an academic authority authorized by the central government, academic authority is the NCTE, shall be eligible for appointment as a teacher. Now see subsection 2, my lord. Where a state does not have adequate institutions offering courses or training in teacher education or teachers possessing minimum qualification, that was the case as laid down under subsection 1 are not available in sufficient numbers. The central government may, if it deems necessary, by notification relax the minimum qualifications required for appointment as teacher for such period not exceeding 5 years. Give me that paragraph where it is. As may be specified in that notification, provided that the teacher who at the commencement of this act does not possess minimum qualification, so there is a time given for prescribed qualification of within 5 years. Then they say. So, my lord, this is exactly what was done. And if your lordships will see page 129 of my compilation, not trouble yourself, my lords, with opening it. Para 30 at page 129, which reads, my lord, the sequence of events which are now well established.
Para
30
of 30
of my page 129 of my compilation.
Yes, both or compilation.
My lord, of Devesh Sharma. My lord, my compilation. My continuation, that brown cover, my lord, that brown cover. Brown cover, my lord, that your lordship had.
Acha.
Brown cover, my lords. Come to page 129 for a moment. Page 129. Page 129.
जी, para 30. Yes.
Which was placed before Rajasthan High Court. The dispute B.Ed qualification was apparently triggered later of the Commissioner of KBS who made a request that since the primary class central school sufficient number of trained diploma teachers are not available, they may be permitted to appoint B.Ed qualified candidates who are readily available. The ministry take cognizance of this and after last consolation that.
B.Ed candidates मिल नहीं रहे थे क्या आपको?
नहीं, my lord, diploma candidates were not there. That is, diploma candidates.
जो आपने ये modification किया है.
Diploma candidates were not there.
Available.
This is not a case where D.Ed were completely outstanding.
यहाँ पर जो
My lords, there are 1 lakh D.Ed candidates available in state of Chhattisgarh.
Okay.
The reason
The
why
people-
the reason for the introduction.
But they have not been selected, they have not succeeded.
Say so subject to
Yes, Mr. sir, बताइए,
So, my lord, I'm just concluding.
हाँ.
It would be a catastrophic situation, my lord. Please, for the time being, my lord, keep aside the rights or interests of B.Ed candidates. Please take, my lord, a larger picture of the state. Thousands of primary schools, my lords, the D.Ed candidates are not available. If B.Eds are, my lords, the schools will become, my lord, non-functional. Is that public interest, my lords? When a lordship exercise the discretionary jurisdiction under 226, plethora of considerations enter into your lordship's mind, not necessarily the individual rights of appointment or promotion. So, my lord, a larger picture will have to be, my lords, appreciated, that it will be a very, very, my lord, sad situation that the children will suffer for want of teachers, my lords. It is not as if B.Ed, my lords, are inherently disqualified or ineligible. Section 23 contemplates that they can pass the bridge course, my lord, within 4 years and be as qualified as the diploma candidates are. I'm grateful, my lords.
Right, thank you. आप बताइए.
May I very briefly rejoin, my lords?
Madam, just here, just another senior counsel is here.
I'm
Let us.
sorry.
My lord, kindly see, my lord, I would like to read, my lord, 2-3 paragraphs of the Devesh Sharma's judgment, my lord. My lord, kindly see what paragraph 3 says. What lies at the core of the dispute before this court is the notification dated.
जी मिल गया.
The notification dated 28/6/2018 issued by the National Council for Teacher Education made in exercise of its power under section 23(1) of the Right to Education Act 2009. This notification made B.Ed degree holders eligible for appointment to the post of primary school teacher. All the time, in spite of the above notification, the Board of Secondary Education, State of Rajasthan, issued the advertisement on 11/1/2021 for Rajasthan Teachers Eligibility Test. It excluded B.Ed degree holders from the list of eligible candidates. This action of Rajasthan government was challenged before the High Court. The petitioner, Shri Devesh Sharma, is a B.Ed. In this context, Devesh Sharma had challenged. Now, my lord, may kindly see para 4.
जी.
So, para 4 is apart from the above batch of petitioners, there was another set of petitioners with their own grievance. These are the candidates who are diploma holders in elementary education, which was the only teaching qualification required for teachers in primary level, and who are aggrieved by inclusion of B.Ed qualification candidates. They too have filed the writ petitions before the Rajasthan High Court, challenging the legality of the notification dated so and so. The state of Rajasthan understandably supported the stand batch of the petition. Now, not in this context, if I can trouble your lordship, my lord, to have the my lord, last paragraph, in the compilation. That is at page 147, which my lord here has given.
147, last paragraph.
Yes, my lord.
Having made the above.
Having made the above determination, we all the same are also of the considered opinion that the state of Rajasthan was clearly in error in not calling the applications from B.Ed qualified candidates for the reasons that till the time when such an advertisement was issued by Rajasthan government, B.Ed candidates were included as eligible candidates as per the statutory notification of the NCET, which was binding on the Rajasthan government till it was declared illegal or unconstitutional by the court. The Rajasthan High Court had rightly observed as under. We are of the opinion that the state government could not have ignored the notification while inviting applications for read, even if the state government was of the opinion that such notification was unconstitutional or for any reason illegal. The same had to be stayed or set aside by the competent court before it could be ignored. Then, my lord, my senior my lord has already.
ना वो देख लिया.
So what, my lord, here what happened? My lord may kindly see on 4/5/2023, the advertisement was issued, my lord. Then the last date of filing the application, my lord, was 6/5/2020, sorry, 2/6/2023. 10/6, the examination held. On 2/7, my lord, the merit list result was declared. Thereafter, my lord, on 11/8, Honorable Supreme Court, my lord, declared this judgment of the Sharma. And on 14/8/2023, my lord, the person, my lord, this Vikas Upadhyay petition in which Vikas Kaushik and other in which I am appearing, this petition has been filed. So, my lord, my result has been called in question by a candidate who, with open eye, knowing all the things, appeared in the examination, failed in the examination.
Less
Less meritorious is calling, my lord, my selection. So that is why, my lord, my senior has read out the judgment passed by the Supreme Court after Honorable Supreme Court, after this Honorable Court passed the order, my lord, that it has to be examined. And, my lord, in this context, the judgment of Honorable Supreme Court is to be seen, my lord.
चलिए देखते हैं हम लोग.
Whether the B.Ed
ठीक है.
candidate could have.
चलिए, we have understood. चलिए, yes, Mr. और कोई तो नहीं है ना? हाँ, बताइए, आप बताइए. आप भी, हाँ, हाँ, आपका ऐड करना बताइए.
इतना ही कहना है सर, ये जो एडवर्टाइजमेंट हुआ एंड टिल द डिसीजन ऑफ द सुप्रीम कोर्ट,
वही चीज तो बोल रहे हो आप भी. हाँ,
देयर वाज नो डेमर और प्रोटेस्ट ऑन द पार्ट ऑफ द पिटिशनर.
हाँ, हाँ, ठीक
They
है.
all had participated. They cannot.
इसमें एक डायरेक्ट जजमेंट हमारे
रिजल्ट पब्लिश हो गया, ये बात मतलब पिटीशन में लिखी नहीं.
even today the advertisement is not under challenge. With the same condition.
Rules, not the advertisement.
Wait, बोलने तो दीजिए, आपको बोलने देंगे. Gone up to the Supreme Court, my lord. In that case also, my lord, that's a PSC matter, my lord. The rule under which the advertisement was issued, my lord, that was repealed before issuance of the advertisement. And then the question went up to the Supreme Court, and the Supreme Court says that, my lord, at the time of vacancy, the rule which was in prevail, that has to be followed.
Yes, your lordship. That is
And,
what
my
the
lord,
entire.
and, my lord, there was no dammer or protest till the new rule comes into picture. Here also, till the judgment comes into the picture, my lord, there was no dammer and protest.
wait. One by one.
आप लोग पैरेलल चल रहे हैं.
In addition to what has been argued, my only submission is that even if the petition is allowed, it will not affect the ongoing recruitment process, which is already culminated by publication of result and by the issuance of appointment order. So it will apply, even if the petition is allowed, it will apply to any advertisement which is published after this present advertisement. That is my submission, in addition to what.
One more thing, my lord, which I want to point out. My lord, in my petition, kindly see the relief clause in Vikas Sharma.
Vikas Kaushik.
Vikas Kaushik.
वही तो किया है ना, quash the notification है ना, यही तो.
Yeah, my lord, 4/5/2023 notification. The rules are not under challenge in this petition. And, my lord, may kindly see what is this notification. Yeah. What this notification says. School Shiksha Vibhag Mantralaya, page 19 of the petition.
जी.
B.Ed 45% और ये जो जोड़े हैं उसी.
हाँ, क्या कह रहे हैं मिस्टर?
ये B.Ed या D.Ed.
हाँ, यही है.
ये इस इन्होंने क्या कहा, उक्त नियमों में जो नोटिफिकेशन था, क्रमांक 100 भारत के संविधान अनुच्छेद 309 के परंतु के अनुसार प्रदत्त शक्तियों को प्रयोग में लाते हुए छत्तीसगढ़ के राज्यपाल द्वारा स्कूल सेवा 100 में निम्नलिखित संशोधन करते हैं. अर्थात अनुसूची 2 के सरल क्रमांक 36 में विषयवार सीधी भर्ती की जाएगी का लोप किया जाएगा. परिशिष्ट 1 के सरल क्रमांक 1 एवं 2 के स्थान पर निम्नलिखित सरल क्रमांक प्रतिस्थापित किया जाए. अर्थात 1 सहायक शिक्षक न्यूनतम और 2 शिक्षक न्यूनतम 45% अंकों के साथ स्नातक, 2 D.Ed या B.Ed या B.L.Ed कोर्स होते हैं. They have sought, my lord, quashing of this notification. Now, my lord, may kindly see what was the annexure prior to this amendment.
2019 rules.
2000, under 2019 rules, which your lordship would find at page 47.
जी ये टीचर ना नहीं देखना है 2 year डिप्लोमा एलिमेंट्री
नेक्स्ट ईयर 1
तो उसमें देखिएगा सर, असिस्टेंट टीचर,
हाँ असिस्टेंट टीचर
में जो ग्रेजुएशन विद 2 years डिप्लोमा इन एलिमेंट्री एजुकेशन, लास्ट वाला जो है उसके बाद और ग्रेजुएशन विथ एटलीस्ट 50% मार्क्स and B.Ed qualification, graduation from institution recognized from NCT shall also be eligible for appointment as teacher for classes 1 to 5, provided that she undergoes after the appointment of NCT recognized 6 months special program in elementary education. In Vikas Kaushik case, Lord, these rules have not been changed. So, if
it's in material. It's in material that they have not been challenged. Then the main matter it has been challenged.
wait please, one by one.
Sorry, Manoj.
So, Lord, what my respectful submission is that if this notification would not have been there, these rules would have been there. But the petition in which, my Lord, I am appearing, I am not acquainted with the other petitions, my Lord, the same. What has been challenged. But here, kindly see this relief flow.
देखिए ठीक है देखते हैं और कोई इधर से कोई और तो नहीं आप बताइए
एनसीटी का नोटिफिकेशन तो उन्होंने अडॉप्ट किया था, इंडिविजुअल उन्होंने अंडर आर्टिकल उन्होंने कुछ रूल पब्लिश नहीं किया था और सुप्रीम कोर्ट ने ऑलरेडी ऑब्जर्व किया हमारा कि नोटिफिकेशन से द फर्स्ट हुआ है which has been declared unconstitutional, which is applicable रहेगा. So here in this case, my lord, the state government framed the rules, my lord, if my lord, 309, my lord, if my lord may allow the petition filed by the B.Ed candidate, it may be observed, it will be applicable prospectively, my lord, and the appointment of the B.Ed candidate shall be protected, my lord.
ठीक है
एक जजमेंट हमने अपने इंटरवेंशन एप्लीकेशन
दे दीजिएगा, हम लोग देख लेंगे
उस जजमेंट में यही था कि अमेंडमेंट चैलेंज किया
this spectrum majority it has not been brought before this one.
ठीक है
completely silent in the petition filed in Vikas Kaushik. It is a material fact they ought to have disclosed it before this one.
चलिए आपने बता दिया ना
very small concluding line. The B.Ed qualification is a very
आप किधर से हैं
for the interveners only, Your
Interveners,
Lordship. Yes, in the same petition.
right
Your Lordship, the B.Ed qualification has been a very well recognized course in the field of teaching, Your Lordship.
right
So in particularly this case, this rule may not be retrospectively
एक
applied.
वो है ना फ्रेज है ना, जहाँ काम आवे सुई वहाँ क्या करे तलवार, वही वाली बात है.
My lords, very briefly, can I rejoin? I will do it very quickly.
Madam, let them complete, then we finally come to you.
Only para 52 में can we look? Only 3 lines. 52 of that Devesh Sharma. What the Honorable Supreme Court has observed.
एक से देवेश शर्मा को
It is very relevant.
एक से भैया रुक जाओ. 52
मतलब 52
पेज
52 paragraph.
ये श्रीवास्तव साहब में लगा था ना, ये देवेश शर्मा ही तो लगा है ना जो पढ़ाया है.
Yeah, it's my compilation. It's there in my compilation.
देवेश शर्मा पेज पैरा 52
मतलब
श्रीवास्तव साहब एक सेकंड जस्ट पैरा 52 तो ये नहीं 52 पैरा 52 तो इसमें है नहीं.
उसमें भी है,
ये
मैंने निकाल दिया.
पेज बता दे यार, सारा बता दे.
52 पैराग्राफ
पेज किस पे है? 52 पेज
डायरेक्ट निकाल दिया.
अच्छा चलिए पढ़ दीजिए. हाँ ये यस
para 52 says the pedagogical skills of a teacher must be given a very high priority, but our priority seems to be different. It is not to impart quality education, but to provide more job avenues to the B.Ed trained candidates. It has been observed by the Supreme Court. The quality, the main thing is the quality of the teachers and the students, my lord. But to provide more job, this is our priority.
Unless we read page para 50 also, if my lords are reading 52, maybe.
That's why the Honorable Supreme Court says that it is an Ultra vires to the Article 21A
My
of the
lords,
Party of the
this is a
Constitution.
complete incorrect reading. My lords will have to read from paragraph 31.
ये stray pieces आपको देखना पड़ेगा.
No, my lords, this is a complete incorrect reading. Please read paragraph 31. Thereafter, you may please read paragraph
Let us
34.
interpret in our own way.
No, my lords, allow me to read those 2-3 paragraphs, please. Allow me
Yes,
to
madam,
read
आप
those.
बताइए. Yes, madam,
Yes.
बताइए, please.
My
what you have
lords,
to say.
let me answer this pedagogical first, and I will just answer Mr. Srivastava's also in very few minutes.
Yes,
Please take paragraph 31. Please take paragraph 31 of Divesh. My learned friend has read one sentence. He's not even read the whole basic part.
Para 31.
Paragraph 31. My lords, my page number may be different because I don't have Mr. Srivastav's paperwork. Yeah.
एक सेकंड रुकिए. Para 31.
Yes.
Yes, madam. Para 31 we
Yes.
have.
It must be emphasized that pedagogical approach required from a teacher at primary level is in some manners unique. They are initial formative years where a student has just stepped inside an classroom and therefore needs to be handled with care and sensitivity. A candidate who has a diploma in elementary education, DED, is trained to handle students at this level as he has undergone a pedagogical course specifically designed for this purpose. My lords may now turn to paragraph 34. A person who has a B.Ed qualification has been trained to impart teacher to secondary and higher secondary level students. He is not expected to impart training to primary level students. Now, my lords, please come to paragraph 38. It is therefore clear that B.Ed course is not designed for teaching at primary level. Moreover, inclusion of B.Ed candidates for primary classes is in the teeth of several decisions of this court that has consistently held that diploma in elementary education, DED, and not B.Ed is the proper qualification in primary school. My lords, that was Dilip Kumar Ghosh, PM Lata, and the other judgments. Now, my lords may turn to paragraph 48.
Okay.
The inherent pedagogical weakness in B.Ed course for primary class is well recognized. And it is for this reason that in the impugned notification itself, it is provided that B.Ed trained teachers will have to undergo 6 months training in elementary classes within the first 2 years of their appointment. In this background, inclusion of B.Ed candidates for primary level is beyond our comprehension. We have seen so far that the need for quality, I can leave that. Now, in that context, read paragraph 52. The pedagogical skills of a teacher must be given a very high priority. But our priority, this he's talking about the government, the learned judge. He's not talking about something. Our priority seems to be different. It is not to impart quality education, but to provide job avenues to B.Ed candidates, as this seems to be the only reason for their inclusion in presence of overwhelming evidence that B.Ed course is not a suitable course for primary classes. Now, my lords, answering Mr. Srivastav's question about the availability of the DED candidates. The Kendriya Vidyalaya had made a request, this my lords will find at paragraph 55 of the judgment, to the minister saying that they need DED. Now, please see the stage at state in Rajasthan. Come to paragraph 63. Please take at bottom of the page the last 5-6 lines.
Yes.
My lords have paragraph 63, the last few lines. So they said, we don't have enough DED candidates, the Kendriya Vidyalaya. Now in Rajasthan, where the matter was filed, please see the last 3 lines. The irony here is that all this is being done when the state of Rajasthan already has more than required number of diploma qualified candidates available. This is besides the fact that there is presently no such bridge course available. At least there is none till the disposal of the petition by Rajasthan High Court. This is all over India. I have an RTI reply. They have no recognized bridge course. I have filed it with my petition. My lord, state of Chhattisgarh has over 1 lakh DED qualified candidates available as on date to occupy positions in primary schools. And this is where the argument that is made by Mr. Srivastav does not commensurate with the facts of the present case. where there is availability of DLED candidates who are trained to teach the primary course, B.Ed cannot be appointed because B.Ed is not a qualification. My lords, the main primary issue in this matter is B.Ed candidates are presently not qualified. There is no course that is yet available at all anywhere. I will just request my friend, there is an RTI document that has been filed. I think it is filed in Bhubaneswar Sahu, which says that there is no, my lords may please
PC
come.
141 of Bhubaneswar Sahu. Page
My
141.
lords may take, yes, page number 141. This is in RTI.
P13.
We have
Annex
received.
P13 of Bhubaneswar Sahu, first petition.
Do my lords have that page?
Yes.
My lords may see this is in RTI, and please see the remarks. No institution is recognized by NCTE for the said course as on date. Please see on the third column, fourth column.
Yes,
the query was whether there is any bridge course. So my lords, today we are talking about appointing candidates who are without a qualification whatsoever to be occupying a position which they are so doing. Now, answering the question, the contention raised by Mr. Srivastav regarding that in the case of Rajasthan, the Supreme Court had said that the Rajasthan government could not have proceeded with an advertisement without including B.Ed candidates at that stage, because at that point in time, the notification issued by the NCTE had not been quashed. That was the finding of the High Court. Can I show you that particular paragraph, my lords, to make it more clear?
We have seen, madam,
Very
please
well.
advance your argument. Please advance your argument.
So my submission is this, my lords, that the Rajasthan High Court struck it down. Rajasthan High Court struck down the central government, that is under the Central Act, the NCTE Act, a notification which made B.Ed as an eligible qualification for appointment to primary teachers. This was struck down on 25/11/2021. There was no stay of this striking down. Once a notification that is applicable pan-India, appropriate to which Chhattisgarh includes B.Ed as its qualification, that particular notification itself is struck down. The question of then appointing any kind of a B.Ed candidate does not arise thereafter. This striking down is on 25th November 2021, not stayed by the Supreme Court. Now a big thing is being said that there is no challenge to the rule. Please see Bhubaneswar Sahu prayer number B, and please read with that page number 41.
34 is the prayer.
My lords, the prayer is 10.2.
At page 34.
Page number 34. So therefore, there is a specific challenge to this, because today the underlying basis of that notification by which an amendment was made to bring in the B.Ed education had gone. My lord's, prayer number 10.2 is, this honorable court may be pleased to strike down impugned annexure 1 of schedule 3 of Chhattisgarh School Education Services Recruitment Promotion Rules, annexure P1, for being arbitrary, illegal. My lords, may please turn to page 41. There, that is where the notification has been extracted.
We have seen.
Yes. This says, in exercise of powers conferred under Article 309, Governor makes following further amendments to the recruitment and promotion rules. Now, what is the amendment that is made? Is to include B.Ed as a qualification. So I have challenged that. Prior to this, B.Ed was not a qualification. This came by virtue of the 2018 notification.
Yes, madam,
NCT. So, my lords, that is my respectful submission. My lords, I'm grateful.
Can I just take 30 seconds to add on?
No, sorry. Chaliye.
Your Lordship, selection has been done as per the existing rules, and the selection process is over, Your Lordship, since the results have been declared on 2/7/2023, Your Lordship. So, that is and those peoples have been appointed also. That is the only submission. Your Lordship.
My lords, appointment is in September. My learned friend must point out, appointment is in September after the judgment of Supreme Court on 11th of August.
ठीक है
Because it
Under
was
the order of
ठीक
the
है
State.
Because
चलिए
it was
ठीक है
state.
रिजर्व चलिए नेक्स्ट केस
Grateful, my
नेक्स्ट
lords.
केस
Much obliged.
Lord, मेरा वो
चलिए हो गया
intervention
आफ्टर
के साथ-
द सीनियर एडवोकेट्स आर्गुमेंट नो फर्दर आर्गुमेंट्स लेफ्ट नाउ
My lord, my-
Grateful, my lord.
Lord,
चलिए
intervention के साथ हमारा judgment
हम
लगा
देख
हुआ
लेंगे
है।
हम देख लेंगे फिर
वो आपका जजमेंट है जिसमें अमेंडमेंट 4-5 का नोटिफिकेशन में चैलेंज हुआ था,
ठीक
11-5 को अमेंडमेंट किया था,
हम्म
वो नोटिफिकेशन आपके सामने चैलेंज हुआ
ठीक
था,
है ठीक
वो पिटीशन डिसमिस हुई थी, उसमें जो पैराग्राफ 33 था वो
हम देख लेंगे श्रीवास्तव हम लोग देख लेंगे
जी
don't
जी
worry,
ठीक
don't
है,
worry.
वो
Yes, sir.
स्पेसिफिकली इंटरवेंशन
Lordship, there are some judgments, I'll just pass it on to the court.
सब दे दीजिए देख लेंगे ये तो विड्रॉ हो गई ना तीन हम लोग के सामने ना
जी।
रिजर्व ठीक चलिए
Item 5, Sri Mukesh Srivastav.
ये दूसरा लग
Final hearing, item 1 to 22. Sri Neeraj Mehta, Sri Bhaskar Vyas.
बोलो उसको